Okay. All right. Good afternoon or good morning, everyone. We'll just give people a few minutes to come in. Welcome. Welcome. Actually, it's our last webinar of the year. Gosh, can you believe it's December?
Unreal.
But I
It's
know.
crazy.
But we already are planning for next year, so we're happy to be able to get this one in for everyone. As people are coming in, just a couple housekeeping items. If you look in the chat, we put the presentation and the evaluation form. You can download it from there. So this presentation, fast patents, fast patent prosecution options, has been approved for one CLE credit through the Pennsylvania CLE board. Again, if you are in Pennsylvania, your attendance will be submitted electronically outside the jurisdiction. You all will receive your certificate of attendance by email in the next week or so, and then you can take the materials, depending on your jurisdiction, and you can submit it, and you can get your credit through there. So I think, gentlemen, we're good. I'll give a little intro and then we'll get started. So we're very pleased today that our presenters are both senior attorneys with Volpe Koenig. So Jonathan Dunsey, like I haven't known you for years. Jonathan Dunsey and Patrick Griffin are here. So John's practice focuses on preparation and worldwide prosecution of a wide range of patent applications, counseling, litigation, licensing, and IP portfolio management. And he has counseled clients of all sizes, and he's part of the firm's electrical group. Patrick focuses on patent application writing and patent prosecution. He's particularly experienced in freedom to operate opinions, as well as strategic invention development consulting in high technology fields. And Patrick is part of the firm's artificial intelligence group and the international practice group. So with that, Patrick, I will turn it over to you.
Thank you, Anna, and welcome everybody. And looking at the attendee list, I see a couple familiar names, some colleagues, some PIPLA colleagues as well, and some new faces. So welcome. My name's Patrick. We have this fast patent prosecution presentation for you today to review some of the ways that we could usher in your patent from the time of filing and reduce the clock. So with that, I'm going to hand it off to John and answer the question of why? Why do we want fast prosecution? Go ahead, John.
Thank you, Patrick. So applicants might be interested in fast patent prosecution because currently at the patent office, there's a very long pendency. We pulled these statistics for the most recent calendar month that statistics are available, and that's the first month of the fiscal year 2025-2026 being October, and we're looking at 22.5 months until first action. In addition, we see there's an increasing pendency. Starting about 10 years ago, pendency was not too bad at around 16 months, but about 5 years ago, pendency started to increase, where now we see it at its present 22.5 months or so. For fiscal year 2025, which ended in September, we were looking at that 22.5 months. So this is a pretty long time to wait for your first action, particularly if you're interested in moving forward on claims and you have claims which might have strategic value for the applicant.
So with that, let me give you a quick overview of some of our topics. Accelerated examination has been around for some time. We're going to discuss how that's been discontinued and some of the options that remain. Prioritized examination is the new game in town. In addition, there's options under bypass applications, how that is affected by prioritized examination. Patent prosecution highway is something that you can use. And there's a new pilot program. So there's a lot of material. We're excited to present it. We would like to take questions. We will address questions at the end. And, should we be short on time, we'll be happy to connect with any of the attendees offline. So jumping into accelerated examination. The general rule is that applications are examined in filing order. Now, you could receive expedited examination by taking advantage of the federal rules under section 1.102 to advance exam. Unfortunately, in July 10th, the program was eliminated, except for its design applications, but that's outside of the scope of our discussion. We're mainly talking about utility. So with that said, what does remain under the advancement of examination? Well, there's the petitions to make special, both due to age and to the inventor's health. They remain active. However, under 102E, the program, which was originally pilot and is now in full effect, is prioritized examination. And let's review each one of those in turn. So a petition to make special on someone's age, basically, if an inventor or one of the joint inventors is 65 years or older, you can petition to make the application special by showing evidence that the inventor is of such age or older. You could do this evidence by a statement from the inventor, the joint inventor, from a registered practitioner, or submitting documentation like a driver's license. The easy and simple way to do this is using the e-petition. This is right through Patent Center. And there's no fee. So to the extent applicants would like to have expedited prosecution, part of the initial interview with your inventors or your client should be, do you have any inventors that make this criteria? And would you like us to submit a petition on your behalf? Now, health doesn't have an age restriction. This is a policy within the rules where if an inventor is going to be unavailable, you could submit for special status. The evidence, similarly to age, you need evidence, right? And so the evidence could be a declaration or more concretely, a doctor's note or other medical certificate. If you're submitting a doctor's certificate or something to that effect, it will publicly be available. We've noted the CFR. Well, that'll be on the next slide, but the contents are available according to these CFR sections. There is no fee. There presently is no form. So traditionally, you would submit a transmittal letter explaining the situation. Now, what that transmittal letter looks like is you have the application number, title of the invention, the inventor's full name, and then you identify the request for special status. Some example language that you could use, undersigned here by petitions, so on and so forth, that the inventor's health may cause the inventor to not be available. Now, take into account that with dependency of 22.5 months, so almost 2 years, it's foreseeable that things like a terminal illness or cancer could directly affect an inventor's availability. And so attesting to a medical condition, those would be examples that you could use. If you do not wish the evidence to be public, under the MPEP section 724.02, that would be where you submit your request. We're not going to particularly cover that request because we want to move on to how do you expedite prosecution. Okay, so under both age and health, you'll see that you will maintain the special status throughout the prosecution. But if you don't have those conditions, well, you ask for prioritized examination. So generally, it's a procedure to expedite examination of an application. There are two options, and they have limited runtimes. So option number one is colloquially called the Track 1 program or prioritized exam. It's for new applications under section 111A, for newly filed bypass under applications under section 363, and it is not available for national stage applications under section 371. John will explain why later in the presentation. The Track 1 program is at the time of filing. It's the keynote here. And so when you enter the Track 1 program, you're on the first cycle of your patent prosecution. Now, when that cycle ends, say you receive a final office action, you have a second chance to reboot the program or go into a second cycle of prioritized exam. You don't have to, but if you were to do it, say when you file your first RCE, option 2 would be prioritized examination, request for continuation. So this will go for the duration of the next cycle. And let's move on to see what this looks like, right? Or more importantly, what is the real goal of all of these things? It's the expedite exam, and particularly for prioritized examination. The USPTO wants to provide a final disposition within 12 months. Approximately 2 months from a decision is when this clock starts. Otherwise, if you do not get the petition granted, then regular prosecution timelines occur. So said another way, when you file your petition at the time of filing for, say, the Track 1 program, you should receive a decision on your petition within 1 to 2 months. And then from that decision date, you will have a 12-month clock to try to get the allowance or some other disposition. There is a limit. 20,000 is the current limit amongst the USPTO. That includes both Track 1 granted requests and RCE granted requests. Interestingly, it used to be 15,000. They've increased it. And, I suspect if it remains as popular as it is, they will increase it again. But that's just my conjecture. So again, what's the purpose? Yes, the 12-month disposition, but how do we get this done? It's you get to control as the applicant when your application is examined, meaning you get to bring it to the front of the line. And with that, the examiners note that there's a special status. And so they have shortened timelines on when they issue office actions, and it's at the top of their docket, and they know that there's this 12-month clock. So applicants and examiners have an incentive to be efficient. What we find is that applications that generally are static, that they are very specific on the claims you need and you do not want to amend, even if they're important, you may have trouble negotiating with examiners. And we're going to explain this process as we get later in one of our examples. So prioritized examination, what does the request look like? Well, there are a few conditions in order to meet the prioritized exam request. First, your application can have no more than 4 independent claims, no more than 30 claims total, and no multiple dependent claims. If you break one of these conditions, you will immediately lose special status. You cannot get it back. The request for a prioritized examination must be present at the time of filing. If you file the day after, if you file your request the day after filing your application, it will be denied because you didn't comply with the timeliness. When you file a request for prioritized examination with respect to an RCE, there is a stretched timeline. You do not have to file it the same day as the RCE itself, but you do have to file it before the next action. Interestingly, if you need to game the system on timing, whether for budgetary reasons or for client approval reasons, sometimes you can predict that after you file your RCE that maybe the examiner might not pick it up for a few months. And in order to get this program, you can delay. The best practice is you file the request at the time of the RCE. Now, moving on to bullet 3, the request for prioritized examination must be filed electronically. The applications themselves must be filed electronically. While it's not required to use the form, this PTO AIA 424 form avoids processing delays. So if you want to get your grant within a month, or as close to that as you can, as opposed to 2 months, those weeks could matter. You also have to include the necessary prioritized examination and processing fees. So there's 2 sets of fees. Now, there's an interesting thing about the form and the processing fees that we'll talk about in the pitfalls. So let's put a pin in that thought real quick. All right, so what are the fees? Yes, it is quite expensive relative to filing a patent application. At approximately $2,000, you can file an undiscounted large entity utility patent at the USPTO to include the basic filing fee, exam fee, and search fee. Well, for an additional $4,515, you can request prioritized examination. This is to get your special status. In addition, you have to pay the processing fee of $150. So when we look at the full picture of what does prioritized examination, it's a little over 2x. So you're paying $6,600 or so for the entire application to be moved to the front of the line. Naturally, you have discounts of 60-80% for small and micro entity. Okay, let's talk about what does prioritized examination look like. We're going to use the filing example and to show you the difference. Now, if you look at bullets A and B and the red text, you can see that at 0 months, if you file without a petition, as John mentioned at the top, it's 22.5 months to the first action. That's almost 2 years. If, as shown in A, C, D, and E, or A, C, and E, if you filed the track 1 petition at the time of filing, you can expect within 2 months to receive the grant of the track 1 petition. And then your final disposition is supposed to happen within 14 months, as shown as at bullet E on the timeline. Now, looking at D, and this is where I want to go back to negotiating your claims. The average timeline to allowance under the track 1 program is 6 months from filing. These are from the USPTO statistics. It's incredible to think that you can file an application and get an allowance within 6 months. Now, what we like to suggest is that there has to be a quid pro quo that the applicant is willing to negotiate with the examiner upon receiving a first office action. If you have a broad set of claims and your client wants to stay on those claims and argue, you might struggle to meet this 6 months. Now, I'm not saying it's not possible. What I'm suggesting is that being able to know what you can add and subtract or change about the claims will put you in a highly negotiable position in order to get a quick allowance. Now, if you're less concerned about the allowance being fast and just more concerned about cutting that timeline in half, naturally the track 1 will get your patent to the front of your patent application to the front of the line. Okay, so it does conclude, again, it's a temporary status. So going back to that timeline, 6 months you can get a notice of allowance, but what if you don't get a notice of allowance? Do you still have special status? Yes, it maintains, because if maybe there's an error in the first office action and you get a second non-final office action. Maybe there's some other conditions that delay prosecution after the first office action that you retain status with. So how does it work? Well, if a final office action, an RCE, a notice of appeal, or any of these other conditions happen, you lose the special status. There's a scenario where if you decide to file an RCE and go into a second cycle of prosecution, you don't need to renew your status by filing a prioritized examination request. You can simply wait for maybe your second RCE and go into a third cycle. So there's options under the prioritized examination. The fact that it is a temporary status, and you can, based on client desires, client business goals, you can file these requests at different times during prosecution. So prioritized examination concludes. Okay. Now, going back to the one slide, I do want to notice that if you take an extension at any point in prosecution, you lose your status. And so going to the pitfalls and remedies, we'll talk about taking unnecessary extensions at the second bullet. But let's return to the paying of fees. Interesting about the form for the prioritization request. It authorizes to pay the prioritized exam fee, but it doesn't note that you should pay the processing fee. So a mistake could be administratively when you're on Patent Center that you don't click the correct items. If you fail to pay the processing fee, your petition will be dismissed for failure to pay fees. And in general, it cannot be remedied. Now, you will get a refund for the prioritized examination, but at that stage, you won't get the special status unless you file an RCE, and you only have that one RCE round to get the special status. So, remedy or possible option is to file a transmittal letter requesting that all fees are authorized to be withdrawn from a deposit account. So to the extent that there might be an administrative error, having that language in there could be a fail-safe. We haven't seen these in action. We've talked to the USPTO about possible scenarios. So, I can't speak from particular experience, but I do know failure to pay fees will eliminate your special status, and the PTO suggested a transmittal letter could help remedy this. Taking unnecessary extensions. I think a good example is if you're filing, if there's an issue with the drawings for some reason at the time of filing, and you get a notice of noncompliance, and you respond to that notice of noncompliance by the 1 month date. And then maybe 3 weeks later, you get a second notice of noncompliance because the USPTO has another issue for some reason. The clock has never stopped from that first notice. So if you don't comply by the 2 month date to the second notice of noncompliance, you'll automatically have to take an extension the day after the 2 month date. This type of unnecessary extension will cause you to lose special status. Now, in this case, because you already entered into the special status, you will not get a refund for that 45K. I'm sorry, 4.5K. So how do you make sure there's compliance with these extension rules? Well, call the USPTO, call the business office. If the prioritized examination is there and it's important to the client, then it's important to follow up and be as diligent as possible to make sure that you don't lose status for some of these administrative reasons. With that said, the last pitfall that we want to identify today is when filing a Track 1 program. So again, this is at the time of filing a patent application. You want to make sure that your request is filed with the correct type. Prioritized examination is not available with nationalizations. That leads me well into John's presentation, who's going to talk, well, if you can't do it with nationalization, then what are our options? And John, I'll pitch it over to you.
Thank you very much, Patrick. So if you're an applicant with an international application, likely you have an invention that may be more valuable than, say, your average invention, where you might just file in the US or in a single jurisdiction. For the international application, if you want to take advantage of Track 1, what are your options? The best approach is to file a bypass application, which you might be familiar with from other contexts. So a bypass application is allowed under 35 USC section 363, which states, an international application designating the US shall have the effect from its international filing date under Article 11 of the treaty of a national application for patent regularly filed in the PTO. In addition, you can file from a foreign application under section 365C of the code, which states that in accordance with the condition and requirements of section 119A and the treaty and regulations, an international application designating the US shall be entitled to the right of priority based on a prior foreign application or a prior international application designating at least one country under the US. So as summed up by the MPEP section 1895, the filing of a continuation, divisional, or continuation in part application of a PCT application designating the US is known as a bypass application. Patrick.
1 second. It should be clicking. There you are.
See, there we go. Got some delay. Thank you. Awesome.
Still on the watch.
So prioritized examination, as Patrick mentioned, is not available for the Track 1 program, under the Track 1 program for international applications, at the time of nationalizing in the US, because if you think about it, really the national stage application under 371 of a PCT is not a new application filed under section 111A. So therefore that 371 application is really structurally different from applications that are normally covered by the track one. But do keep in mind that during prosecution of your normal national stage, you can petition for prioritized examination in the context of an RCE, one of those PE RCEs that Patrick mentioned. So there is a failsafe, but again, that requires getting to your final action and then following the RCE. So if you really prefer fast prosecution, filing the bypass application with the track one petition under the track one program is the best option. Some delay.
John, I'm here. I'm trying to advance the slide, but
Okay.
there's a I'm getting a red screen.
Okay. That's awesome.
Give me 1 second as I bring this back up. Apologies to all those on the CLE. It's a technical difficulty out of my control. So I'm spinning over to a different one.
Let me know if you need me to start my stuff.
If you want to bring it up in the background.
Okay, I'll start doing it.
It's clear. My iGel rebooted.
Okay.
So my desktop is open in maybe about 13 more seconds. I should have control again.
Awesome. Okay.
John, I think you're okay just to continue speaking until we get up because the people have the course materials.
Oh, awesome. Okay. So thank you. Okay. Thanks.
I'm back
Thanks
on in advance.
Got it. Yep. I see it. To obtain benefit under 35 USC sections 120 and 365C of a prior international application designating the US, the continuing application, our bypass here, must include a specific reference to the prior international application, be co-pending with the prior international application, and have at least one inventor in common with that prior application. So as we all remember, co-pending for for the international application for the US means a bypass application must be filed within 30 months of the original priority date of the international application. So that's 30 months from that first jurisdictional filing. In the US, it could be your provisional application. So note that the track one petition in the request for prioritized examination must be submitted when filing the bypass. So you file those together if you want the track one.
It should be advancing.
So, okay. So here's a basic example of timing for a bypass. So again, you're filing that bypass continuation at, say, 30 months. Your deadline in the US with the track one petition. We estimate that your time to allowance is 36 to 37 months from the priority date. So how do we get there? So looking at point A, that's where your priority application is filed. Say it's a provisional or in the US. It could be a non-provisional, but at 12 months, you're filing the international application. Again, you have to designate the US as you do with all PCTs where you want to designate the US. Then at the 30-month date, instead of going national phase, you file a bypass con with the track one petition. And then we estimate at that point C, then you wait another 6 to 7 months for a total of 36 to 37 months from your priority. And you can get an allowance. And this is per Patrick's timeline on his earlier slide. So that's pretty fast for a PCT application to go from priority to allowance. Patrick has a different gloss, a different spin on a timeline based on strategic analysis of a client. Patrick, do you want to? I think you're on mute.
Yes, sir. Thanks, John. Thanks for the pitch over. Okay, so you don't have to file at 30 months. You could actually use a successful US prosecution within the 30 months to then de-risk your decision as to whether you should nationalize or not. And this timing example showing an earlier strategy, I'll go back. So again, so this is John's slide. At C is when you file the bypass con. But the priority application at A might have been in another country. So instead of filing a priority application, maybe you file your international application at 0 months. And then your client takes time to decide how, whether it's their software for like, you cover the versioning that's been happening over the past year, or maybe you got some seed money between 0 and 12 months later. Maybe the budget got approved. I don't know, whatever the reason is, at 12 months, E on this chart, you could decide here that there we are. At E, you could decide to file the bypass application with a track 1 petition, same day, remember. Now, you receive the grant within 2 to 3 months. Again, we're estimating more, it's 1 to 2, but on this one, we're kind of being a little bit more conservative. And then at H, you're supposed to get the final disposition. And if you're in a position to work with the examiners and maybe expedite the negotiation to allowance, you could receive the allowance at the 20-month mark. It's possible, and we've seen it happen. What's great about having that allowance 10 months before the deadline to nationalize is now, wherever you want to go across the globe, you have this US-based application to say, we can spend the money on these other jurisdictions with a high confidence that we could get a grant. No guarantees, but now you're making educated decisions with support by the 30-month date. John, I think I pitched back to you, but is there anything else you wanted to add?
No, I would just say, just underline your point of the strategic value of being able to have a US allowance in hand for strategic applications. So usually claims in the US, not for all, but for most applicants, are the ones that lead and dictate your global strategy. The US, as we've seen, is not the fastest jurisdiction. And compared to a lot of foreign jurisdictions is slower. So having that allowance in hand lets you then dictate your international strategy across the board. So you can file in other jurisdictions at your 30, 31, and 32-month deadlines, aligning those claims with the US, making your portfolio a lot stronger globally.
Yeah. Another way to look at this chart, based on what John just said, is that if you are a domestic US client and you file provisional at 0 months, instead of filing the bypass at E 12 months, you would file the non-provisional under 111 simultaneous with a PCT international application. So the 30-month date would still be calculated the same. But by filing the 111 with the petition, you could still get the same timeline and, again, de-risk your international portfolio. All right. So when you have that in hand, John, I have my US allowance. This is exciting. What can I do with that?
So, as I said, you can use those in other jurisdictions, and one way to use those is through the Global Patent Prosecution Highway Program. So this program is a framework established by participating patent offices around the world to speed examination and increase efficiency. Under PPH, an application whose claims match those in a corresponding application determined to be patentable by an Office of Earlier Examination, an OEE, is eligible to go through an accelerated examination at an Office of Later Examination, OLE, with a simple procedure upon an applicant's request. Importantly, there's no fee to file petitions under PPH program, so which is good because compared to the track 1, as we've seen, those fees can get steep. So again, say you have that US allowance, you can use the PPH to go into, say, another big jurisdiction like China, Japan, and hopefully get a allowance very quickly in those jurisdictions. So the PPH provides benefits to applicants through faster examination, lower prosecution costs, stable patent rights around the world, and to patent offices themselves through reduced search and examination burden and improved quality of examination overall. Currently, there are 56 patent offices that participate in the global PPH. For the US, there are 28 patent offices that are global and IP PPH participants. Separately, there are 11 patent offices that participate in a bilateral PPH program with the USPTO.
And John, if I may add the distinction, this is a good example of the bilateral agreements, say with US and Taiwan versus
Right.
the global of China.
Exactly.
If you want to say a note on that at all.
Yeah, I'll just say that the global has a standardized approach and allows you to use a common form, and the bilateral are individual agreements with the PTO for those particular jurisdictions, and each of those bilateral programs has their own form, which are available on the Patent Office website. The program with Taiwan has to be bilateral because China is the participant in the global program. And as seen, say, with the PCT applications in general, having China as part of the organization means that Taiwan cannot be part of it. So if you do have a Taiwanese application, though, you can use the bilateral program. And we have had success of that, getting a Taiwanese grant and then getting an allowance in the US based on the Taiwanese grant.
And back to the point, if you were to file a provisional in the US and then at the 12-month date, file a 111 application, a PCT application, you would deliberately file a Taiwanese application with the intent of the Track 1 grant in the US would allow you to both PPH bilaterally to Taiwan and then globally to China.
Right. That's a great point. You can use the PPH going the other way. Right.
John, if you want to continue to the next slide while I'm waiting for the
sure, no problem.
Regain control. Apologies
So,
again for the second.
No problem.
The second I jumped the boot.
Yep. A U.S. patent application is eligible for PPH if the application shares a common earliest priority date with a related application from a partnering PPH office. The applicant has received an indication of allowability for at least one claim in the related application. All the claims in the U.S. application sufficiently correspond to allowable claims in the related application. So that is the key determination for the PPH, for the examiners, whether the claims sufficiently correspond. And if examination has not begun on the US application. So if the examiner hasn't picked up the case yet and done his search and done work on it, you can still use the PPH. So thank you, Patrick. The slides are coming through here. And again, the highlight is on the, if you don't remember anything else on the slide, remember that the claims have to sufficiently correspond with each other. So the MPEP section 70802C provides a regulation of the PPH program and explains that the participating patent offices have agreed that when an applicant receives a final ruling from a patent office that at least one claim is allowed, the applicant may request fast-track examination of corresponding claims in a corresponding patent application that is pending in a second patent office.
And John, if I may add, the reverse of the sufficient corresponding applies. So if your claims in the US have distinctions when you file in China, maybe for language translation or something of that effect, or if you filed for a certificate of correction and the Chinese office identifies it, they might deny your PPH request Chinese office. Similarly, in Europe, they have a stricter standard regarding claim language and embodiments within your application. So, it goes both ways with the sufficient correspondence. You should be very much aware that if you're going to take a successful Track 1 allowance, that the claims that in the other jurisdictions, you've had a chance to discuss them with your client and possibly colleagues in those jurisdictions.
Those are great. Yeah, those are great points, Patrick. Thank you. And as we'll see later in the pitfalls, the relation of the dependent claims and independent claims also matter for sufficiently corresponds. So some guidelines to keep in mind that the PPH program is for utility patent applications that are and original utility patent applications. So in other words, the application is not eligible for PPH if it's a plant application, design application, reissue application, part of a re-exam proceeding, or an application subject to a secrecy order. So to file for PPH, start with your PPH request form. As we mentioned earlier, if the other patent office is the OEE is part of the global program, then you use the PTO SB 20 GLBL form. For the bilateral OEEs, there are a whole list of forms on the patent office website, and you pull that particular form. Added to that request form, you provide the supporting documentation. The main document is a copy of the OEE work product. So one way to provide that would be simply marking on the request form that the applicant requests the PTO, obtain it themselves from the dossier access system or from Patent Scope. If the allowance is not a first action allowance, a copy of the office action immediately prior to the allowance must be provided. So even if you have an allowance, the examiner is not just going to take the say-so of the prior examining office. They are going to want to look at the office action and dig into the case a little bit. If these documents are not in English, translations must be provided, but thankfully machine translations are acceptable. In addition to the office documents, you want to provide an IDS listing the references cited. As a reminder, if you are using the PPH in a US con, provide the actual copies of a foreign patent and a non-patent reference. You cannot rely on submission, of those documents under the parent. So normally in a con, you might have a whole list of references. You don't need to resubmit them in your con, even if you want them on the face page of your continuation patent. However, for purposes of the PPH, if those references are used by the OEE, you need to resubmit them. Thanks, Patrick. So all right. So with your PPH, you can file a preliminary amendment to ensure, again, that all claims in this application sufficiently correspond to the patentable allowable claims in the OEE application. That preliminary amendment could be filed shortly before or shortly after your PPH, but you really need to do it so the examiner picks this all up together. So I really recommend that it be filed at the latest with the PPH. If the OEE work product is from a PCT application, the latest PCT work product must be submitted. And in an EPO application as the OEE work product, the extended European search report may be submitted without having to wait for the EPO office action. So this lets you move forward more quickly with the PPH, which is a nice feature. For a US national stage application under 371, the PPH may be submitted with national stage filing or any time prior to the start of substantive examination before the examiner picks that up. So
Hey,
if
John, I was going to add, while we didn't cover this because of the timing, the scope of a Chapter 2 demand while internationally prosecuting, that is also something where the PPH could work for the global program.
Right. And yeah, I didn't point that out, but if the OEE work product is from a PCT application, that's one of those that can be used. Yeah. So if you've filed that demand and gotten that out, and if you've gotten your international preliminary report of examination, that can be used. So if your petition is granted, a decision on petition will be mailed, and then your application is accorded special status, which is retained throughout the prosecution of the application, including after RCE. So that's a bit different from the Track 1 program. Under special status, the application is examined ahead of other applications in the regular term. If the special status is no longer desired by the applicant, say you have a change of strategy and you want to take things more slowly, unfortunately, you can't change that in the current application. You would have to file a continuation application, and then the application would be filed in the regular term. If the petition is dismissed, the applicant has 1 month for mailing to perfect the request. There are no extensions of time available for that. If the deficiencies are not corrected, the application will await examination in its regular term. Between the two, dismissal and denial, you definitely want to have your petition dismissed because you can cure that. Because unfortunately, if the petition is denied, the applicant may not file a new or renewed PPH request for the same application. Usually the denials for uncorrectable deficiencies, such as the examination has begun. As we mentioned before, the key point in the PPH request is that the claims between the OEE and the OLE applications must sufficiently correspond. What does that mean? The claims must be the same or similar scope. In particular, if you have a narrower claim, that claim can be used, and that claim will also sufficiently correspond if it is presented as a dependent claim of a claim that is itself of the same or similar scope. To me, when I first came across this in the PPH program, this was a bit counterintuitive. If you had an independent claim that was narrower than a claim that was allowed, why wouldn't it sufficiently correspond? That should be no problem. It's already been found allowable, or all you're doing is narrowing it. But the PTO will not accept that as sufficiently corresponding. So the easy solution is just put that narrowing feature in a dependent claim, have it depend on the allowable independent claim, and you can get both claims. Another point to keep in mind is that different categories of claims do not sufficiently correspond with each other. So in other words, if you have an apparatus claim, that would not sufficiently correspond to allowed method claims. So for a request to be grantable, substantive examination of the application must not yet have begun, as we mentioned earlier. What does this mean? So a notice of missing parts itself does not indicate substantive examination has begun, so you're okay if you just address that. Further, a restriction requirement alone does not indicate substantive examination unless the examiners also happen to have started work and begun his search process. If substantive examination has begun and entry into the PPH is still desired, you can file a continuation or divisional application and then file that with a PPH request. If the PPH petition is granted, the examiner will still undertake substantive examination. He's not, as I mentioned, just going to rely on the earlier office. However, PPH applications generally enjoy higher allowance rates. One benefit is that the patent term adjustment still applies, and another benefit is that extension of time is permitted. So unlike your Track 1, if you need to, for whatever reason, you can take an extension and not get booted out of the PPH program. There's a little bit of an extra program applied to the PPH now for certain jurisdictions. In 2022, the PTO and the Japanese Patent Office established a voluntary PPH improvement initiative, setting PPH pendency targets. Since then, several offices, such as Korea, China, Austria, and Finland, have joined that program. The pendency targets for the PPH Extra program include 3 months from completion of the PPH request to the first action on the merits, and another target is 3 months from the applicant's response to that first office action on the merits to a subsequent office action. In general, these targets have been met by the PTO and the Japanese Patent Office. We can see here, these are the latest PTO statistics. These don't run fiscal year. For some reason, these statistics were calendar year, so we don't have them yet for 2025. Presumably, we'll have them early next year. But as you can see, for the past several years, the PTO has met or been very close to meeting that average period of completion from the request to the first action on the merits, and then very fast to get a for the period from the applicant's response of to the first action on the merits to a subsequent office action, including an allowance. So that 0.9 months is very quick. To me, that makes sense because those who participate in the PPH usually have focus to the claims that they want. The examiner is also motivated to reach an allowance or reach some kind of dispositions on the case because they know the applicant is paying attention to the case. So again, the PPH program doesn't have a fee. And so for a program without a fee, to me, these are pretty good timelines. So compared to actions around the world, here you have PPH programs that have on the left, the PPH size means how many PPH applications do you deal with in your patent office? So for those patent offices that deal with 100 or more PPH applications in a year, there were 2,560 allowed at the first action out of 7,772 first actions for a first action allowance rate of pretty high at 32.9%. And similarly, your timeline for decision to first action is pretty quick at 72.5 days for these bigger offices. Who are the bigger offices? They're those you might expect: the US, China, Japan, Europe, some individual European jurisdictions, and some of the more active patent offices around the world. So this is definitely a well-used program globally. So what are some of the pitfalls and what are some of the remedies for the PPH program? If the applicant fails to provide the most recent office action rejection, the PPH petition will be dismissed. So you don't want to only provide that allowance. Again, you want to provide that first action, unless there's a first action allowance, then of course that would stand. So if your petition is dismissed for that reason, it's an easy remedy. Just go back and include the most recent rejection before the allowance. Another pitfall is if the applicant fails to provide copies of references in a continuation application that they had previously provided in that continuation application. Again, the remedy is just resubmit the IDS with actual copies of the references. Recently, on October 28th, the USPTO announced a new approach for docketing of PPH cases. They will docket PPH applications based on pendency of non-PPH applications in the same tech area, targeting a pendency that is approximately half the time of non-PPH applications. Now, as we've seen, pendency for non-PPH applications is quite high. So at over 22 months. So does that mean the PPH applications will now face an approximately 11-month pendency until the first action on the merits? That's an open question, and it might push applicants to other forms of fast prosecution, such as the Track 1 program. So I don't know if you have thoughts on that, Patrick.
Yeah, it's just interesting because it feels like it waters down the advantage to doing
Yes,
or to having maybe uniform prosecution. So again, our goal is to address the 22.5-month delay to first action. And so success in another jurisdiction is not as successful now if you don't get to reduce it, if you only get half time. So I digress.
no, that's a great point. And I do think this is pushing applicants to other programs. For some reason, the PTO now does not want too much participation participation in the PPH. I do wonder if they're trying to push applicants to track one to get those nice fat track one fees. But just a theory.
Yeah, what's interesting too is you can do both, right? The special status of moving your application to the front of the line, and then at some later point before you get the action, like if you get the decision to grant, I'm sorry, if you get your decision to grant the prioritized examination request and you're diligent enough to like next day file a PPH request before the examiner picks up the case, there's a scenario out there where you could get expedited examination using somebody else's claims. So again, if you're ready to negotiate, you have a lot of advantages under prioritized examination. So next slide, John.
Yes, please.
This is a fun one. Okay.
So with the, I'm not going to say demise of the PPH, but maybe the deprioritizing of the PPH, as we discussed, you could use the track one, but another option now is a new program the PTO just came out with. Again, it was the day before, coincidentally, their PPH announcement that on October 27th, the Patent Office has begun accepting petitions to make special applications for a first office action for applications under a streamlined claim set pilot program. The requirements are that the application must be filed before the pilot launch. So again, before that October 27th date. It must be a non-continuing application, must be an original non-reissue application. There must be no non-publication request, and it must be a utility non-provisional application filed under 111A. So in other words, national stage applications under 371 are not eligible. Inventors are limited to only 4 applications in which they can file this. You can claim the benefit of an earlier provisional or foreign application. The filing requirements before docketing to an examiner must be satisfied, including there has to be only 1 independent claim and up to 9 dependent claims. So they really want a focused claim set. In addition, no multiple dependent claims. Dependent claims must be in proper dependent form under Section 112D. Reference to the previous claim must appear in the preamble. The dependent claims must be directed to the same statutory class and no mixing apparatus and method claims. You can file a preliminary amendment with a petition to clean up your claims and get them in shape for the program. But remember, the claim requirements are maintained throughout the remainder of application pendency. There's a form for this program, the PTSB 472, and the fees are fairly reasonable. 150 for a large entity, 60 for small, and 30 for micro. The program purpose will be to assess the effect of having a limited number of claims under examination on pendency and examination quality. It will be evaluated as data will be collected on the pilot application as it progresses through examination, and avenues of feedback will be provided for applicants. Since this is a pilot program, there are certain program requirements. Right now, approximately 200 applications will be accepted for each text center. The PTO plans to update those petitions on their website. There will be no opportunity to correct dismissed petitions. So do we have time for, yep.
Yeah, so with that, we're at the bottom of the hour here. We definitely appreciate the questions that we have. I don't think we have enough time to run through them. Maybe I'll add one anecdote. First, thank you, John. Thank you, Anna, for setting this up. Thank you all for attending. John and I are both senior attorneys. We love this stuff, and if you have additional questions, please contact us individually or as a pair. Our emails are at the end of the presentation. Naturally, you can find us on the website. So whether you're presenting to an investor panel or you're putting together a portfolio like strategy for a boss or like the IP council, or however you're packaging this, what's interesting is that both PPH, track one, and strategic timing can eliminate the costs. I'm sorry, can eliminate the timeline that's in front of the USPTO of the 22 and a half months. And the costs associated with the reduced timeline are gained back by reducing the timeline. Having a patent, say, a year and a half ahead of time means you have that much more pendency on your term rather than waiting for it to issue, a year and a half after the first action. So there's justifications that we'd be happy to further discuss as to why you would do these programs despite the cost, the upfront costs. Anna, I think, and
So yeah, let me just,
yeah,
I'm
just
sorry,
turn it over
Patrick.
to you at this point.
Yeah, real quick. So, attendees, thank you so much. Again, if you weren't able to download the course materials, I understand some of you had tech issues. Just email VK webinars at vklaw.com. I did put that in the chat. Your attendance has been electronically recorded, so if you stayed on to the end, we were using that as your proof of attendance. And again, everyone will receive your certificate. So thank you. Great job, guys.
Thank you.
And happy
Thank you,
holidays,
everyone.
everyone.
Happy holidays, everybody.
Happy holidays.